Well, as many of you will be aware of, also those who are not working and living in Europe, in the European Union, I should say. In the European Union, it's different from the OECD, where things usually work through what you can call soft law, not binding law. It's recommended, and many countries will act in accordance with the recommendation, but you cannot go to court. Soft law cannot be enforced in court. Well, in the European Union, many of the actions that were developed by BEPS, but were not made mandatory to be implemented by the 100 plus countries cooperating within the OECD initiative. A lot of these optional things were taken over by the OECD and converted in directives. So you may have heard of the ATAD, the anti-tax avoidance directives, ATAD 1, ATAD 2, and a week ago, the European Union announced it's going to be an ATAD 3. These directives are enormously broad, very detailed, and very effective. So the EU is actually providing an enormous assistance to the OECD by taking over to enforce initiatives that the OECD cannot enforce itself. So the OECD action that started in 2013 was, for the time being, completed by the OECD in 2015, but then effectively taken over by the EU. And well, of course, the EU only works for the 27 EU member states, and all the other states, are not affected by the EU actions and the EU directives. But having these examples of EU action implemented by the 27 states, they serve as an example for countries outside. So they are not binding, but they give great ideas to be used as some sort of best practice to be copied by other countries. Well, a week ago, that's interesting that the EU came out again with a number of initiatives. That's going to be my concluding observation. These 4 initiatives take things again a step further. The first initiative is that the EU will bring a proposal which will require multinational enterprises to publish their effective corporate tax rate. It doesn't say here whether it's going to be an average rate at the global level, whether it's going to be a rate on a country-by-country approach. It's going to be published, the effective rate, the real tax they pay, income tax, corporate income tax. Well, the second point is the third ATAD directive, as I said, and that will specifically focus on the use of what they call shell companies that are usually administered by trust organizations. They announce a directive that's going to be prepared for countering the use of such shell companies. It's going to be a hot topic here in Holland. It's not an unknown phenomenon. We have a lot of trust companies, like in many other countries, and they will be undoubtedly affected by this new initiative. A third thing is that the European Union is thinking of initiative to counter double non-taxation in cases where, from ordinary countries like EU countries, interest and royalty payments are made to low-taxing countries. Holland itself, as a matter of fact, has been introducing. Holland never had a withholding tax on interest and royalties until last year, when it was introduced on interest and royalty payments going to low tax jurisdictions, or being paid within a group structure where it was not perfectly clear that the recipient is going to be ordinarily taxed on that income. And now this initiative is also suggested by the European Union itself. So there's going to come perhaps a directive that will provide for such a withholding tax to be applied EU-wide. And well, the fourth initiative is an implementation again through a directive of a corporate minimum tax rate, pretty much pillar 2 of the two BEPS pillars. Pillar 1 dealing with digital companies, pillar 2 dealing with effective minimum corporate tax rate. EU is already thinking about it because in the OECD progress was sort of limited. Now with new guidance from United States, things look much better. So as soon as things are going to be implemented at an OECD level, the EU will step in to make binding what may not be binding in every respect outside the EU, will make it binding for the EU member states. Well, so far my my presentation. So I'll be happy to answer questions. And I think Rustam, you were going to send me maybe you've sent me a message by email that I will look at quickly to see.
Yes, it's actually I sent you 3 different messages because the questions were coming in, so I just decided to pass them on. The last one is particularly interesting. So this is the question from Tiago.
Let's see. Yes. Okay, so give me a little time so I can read them.
Well, meanwhile, I can do some administrative work. So let me demonstrate the whole schedule because we are just opening this series of lectures, and we are inviting you to attend more of them. Most of you had been already on LinkedIn page of the event, and for those who do not, I invite you to come and make the rest of the people known of your participation and presence there. So please share, please like this page. And here we have the schedule of other lectures to be delivered. This is a lecture of Victor Machekin and myself. In 1 week from now, we will discuss BEPS, MLI, principal purpose test. And then we are going to have on 9th of June. And this is, by the way, all scheduled for 6 p.m. West European time, CET time zone, the 9th June, Wednesday, taxation of artists and sportsmen, Mario Tenore, very prominent expert in this area. 16th June, US International Tax Developments, David Borinsky. On 23rd of June, we will be discussing lives of directors of multinational enterprises. Devrim Turker will be with us. Beneficial ownership will be lecture on this topic will be delivered by Monia now. 7th July, exchange of information, Alina Guseinova. On 21st of July, Chinese international tax dispute case study. Yemin Ku will share with us information on this particular topic and on her course. She prepared a special course on this, so very interesting and exciting. And as you can see, we have few free slots still. So 14th of July is not covered. And well, if you have a topic to propose for discussion, please feel free to contact us. Please feel free to indicate this in the discussion section of this LinkedIn event, and we will be happy to make it as interactive as possible. That's the idea.
Okay. I think I see 3 questions. So one from Thiago Neves, and then from Blaburilov, and then
Niels Rogers asked, well, not really a question, but rather proposition. And well, yeah, if you answer three of them.
Yes, but so you have Thiago, we have Lat, and we have question by Ivan. Is that correct?
We have, yeah, we have question from Ivan. From Tiago, I will well, pronounce out loud maybe a couple of other questions if you still have.
Okay. Okay. Well, let me start with a question from Ivan. So he said, "What's the name of the court entitled to settle disputes arisen in bilateral investment treaties?" Well, so there are different organizations. The Permanent Court of Arbitration in The Hague, which is an independent court, but as I said, it's not a real court. It's more an organization because they don't have judges themselves. No, they accommodate arbitration panels. An arbitration panel is an ad hoc panel appointed to decide one particular case. There is no sort of permanent body that will deal with these cases. There is in Washington D.C. under the auspices of the World Bank. There is another arbitral organization. It's not an area of which I have special knowledge, but I'm familiar with these two instances. So again, these are not courts. These are organizations based on agreements that set up, in case of a dispute under bilateral investment treaty, a ad hoc panel, a panel created, as I indicated, one arbitrator appointed by the investor, the other arbitrator appointed by the country, and the two people will together appoint the third arbitrator, and the three of them will decide the issue in the form of an award. Then we get to the, let's see. Let me read. Dynamic interpretation of the OECD commentaries. Is that also giving rise to sort of a retroactive effect? It's sort of the opposite, I would say. Okay, let's take a year, let's say 1990. There was a treaty concluded between two countries, A and B, in 1990. And then in today, 31 years later, an issue arises. And the issue arises on the interpretation of the treaty. And the treaty uses many words. Some of these words and terms and expressions are defined. What's a PE is defined in the treaty. But for example, what's an employer is not defined in the treaty. And for such a term, you may need to go to your domestic law. And the question is, domestic law as it read in 1990 or as it reads today? Of course, in 1990, the two countries came together, agreed on the treaty text, and that's it. So when they agreed on the treaty text, the law of the one country and the law of the other country were the laws these two countries knew of one another. So when they decided on the treaty text, they knew that the term employer would mean the meaning that term had in 1990 in the other country. So the normal way would be, if there would be no rule available, if you interpret a treaty, that you look at the meaning of a term at the time the treaty was concluded. And in the old version of the general interpretation rule of Article 3.2, that is what that provision said. It didn't say that you have to look at the current meaning of that term, and that's what it says today. So today, under Article 3.2, for the establishing the meaning of a term that is not defined in the treaty, you have to go to domestic law, and you look at the domestic law of the countries as that law reads now. So it's not sort of a retro fact, I would say the law of all days is interpreted on the basis of a meaning that didn't exist yet, perhaps in that time, but that was arising later, namely in the time that the case under which the treaty was to which the treaty was applied came up. So it's an interesting comparison. I didn't think of it myself. Thank you so much, Vlad, for bringing it up. But I think it's sort of the opposite of retroactive. And my Latin is not good enough that I can think of another term for retro to look forward rather than backward. Then we get to
Kees, may I briefly intervene, because Vlad is from Russia, and I think what was the thought behind this question. Sometimes Russian tax authorities and sometimes even courts, they go very far with interpretation of various anti-avoidance provisions. For example, there have been cases when taxpayer have been denied tax treaty benefits in respect of capital gains on the basis that they are not beneficial owners. So basically, they somehow connected beneficial ownership. In Russian tax treaties, it's never conditioned for application of tax treaty benefits. Sometimes, well, it's almost always conditioned for reduced rate for dividends. Sometimes it's conditional for royalties and interest. And step by step, tax authorities, they say, okay, yeah, we do not see provision on beneficial ownership in Article 11 in tax treaty with Luxembourg, for example. But from general sense of OECD commentary, we conclude that you still have to be. Then the question, what is the point of mentioning beneficial ownership in double tax treaty?
Sure.
So just take it out. And there have been even further going Ukrainian decisions when in 2020, for example, when MLI was in effect in Ukraine, they started applying this retroactively to tax years 2016, 2017. And it's very straightforward stated. We understand that MLI didn't exist then, but from the spirit of the law, from the feeling of the justice, we feel that we are obliged to prevent somehow this tax avoidance. So the concern is that somebody can take some little piece from OECD commentary and override the whole existing practice. That's the fear, the concern.
Well, the OECD commentary, I think since 2003 or 8, I do not know exactly, but there is a reference made in the OECD commentary on Article 1 that there is a guiding principle underlying the, I'm just reading through the commentary, there's a guiding principle, here it is. I cannot. Here it is, 61. So in the current OECD model, it's important to note that it should not be lightly blah, blah, blah. A guiding principle is that the benefits of a double taxation convention should not be available where a main purpose for entering into certain transactions or arrangements was to secure a more favorable tax position, and obtaining that more favorable treatment in these circumstances will be contrary to the object and purpose of the relevant provisions. So since, let me see, this was introduced in 2003. So now almost 20 years ago, it was included in the OECD commentary. Well, the whole question is, if you're interpreting and applying a treaty that was concluded before the MLI and before a treaty may be amended based on the new text of the OECD model, the 2017 update, whether this statement in the commentary is sufficient to apply a sort of non-expressly included main purpose test. And well, there's a matter of interpretation, and this is a difficult issue in Holland. Courts until recently said no. If you want to have such a principle that should be laid down in the treaty, or the treaty should refer to a domestic rule that embodies that principle. You cannot sort of assume that it's underlying the entire treaty. Other countries have been more sort of faithful to what is stated here. So there is no right answer there. Of course, also here, things will be helped enormously if there will be a top court that could sort of rule on this, because there's an enormous divergence between domestic approaches to this issue. That's all I can say. So the need for a top court is clearly there. The idea has been around, as I indicated, for a century. My feel is, although I'm already quite old, that I may see the day that we're going to have such a court. I think it's sort of in the making. I wouldn't be surprised that within the next 10 years or so, some initiatives will be taken that we effectively will have a possibility of having things checked at a central level. And this is simply, one of the many examples that says, we should have that, because we simply cannot live with every country, every tax authority deciding for itself how that should be read. Fully agree. Okay, shall I go to Thiago Neves' question?
Yeah, please.
Let me here. We also know what my view is on the shifting of the burden of proof. So who carries the burden of proof where there is a transaction that supposedly is abusive? Well, it very much, I would say, depends on the text of the anti-abuse rule you are applying. If you look at the MLI and you look at Article 29 of the OECD model, where the well-known principle of purpose test is laid down, it says, let me read to you. A benefit under this convention shall not be granted in respect of an item, blah, 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 if it's reasonable to conclude that, having regard to all relevant facts and circumstances, that obtaining that benefit was one of the principal purposes of any arrangement or transaction that resulted directly in that benefit, directly or indirectly in that benefit. And then it says, unless it's established that granting that benefit is in accordance with the object and purpose. Well, this phrasing provides how the burden of proof is divided, I would say. I think if the tax authorities believe with avoidance that conflicts with this rule, the authorities have to prove that the principal purpose of the arrangement is obtaining that benefit. The principal purpose. It doesn't say that the people involved personally in their mind needed to have that sort of intention. That is difficult to prove, of course. That's a subjective thing. It says here, you got to check whether the purpose of the structure of the agreement or whatever you set up was to obtain the benefit. That's something that you can construct. In the OECD commentary on this provision, there is a very helpful example that says, assume a company in one country that has an interest of 20% in a company in the other country, and there was no treaty. And then they're going to conclude a treaty. And under that treaty, the subsidiaries country's dividend tax must be lowered from a maximum rate of 15% to 5%. And in many treaties, it's got to be even 0. But that reduction from 15 to 5 or 0 is only affected if you have a participation of at least 25%. What if the parent company now decides to expand its holding from 20 to 25 or more than that. What they are doing, buying those additional shares, is obviously obtaining a benefit under the treaty. That's the only purpose. They were happy with the 20%. Now they're going to have 25. But the example says those additional 5% you're buying is in agreement with the provision, because the provision says if you're a major shareholder, you should not suffer from economic double taxation, being taxed again, getting a withholding tax that you cannot credit because you're exempt on the dividend that you receive. And being a major shareholder, the commentary says 25% was just a number. We had to put something in the treaty. So if you have 20% and it happens to be below 25, now bring it up to 25 in order to get a benefit, you don't violate the spirit of the provision. So here it would be the taxpayer that would say, listen guys, what I'm doing, I agree with you. I did it to get the reduction from 15 to 5. But what I did, look at the background, look at what is written in the commentary, is perfectly in line with the reason that the OECD model provides for a lower rate. So that's how these things are being divided. Of course, this is a simple example, and in practice, of course, we have, we have a zillion shades of gray, and it will be difficult to, in many cases, to say, this is in line with the purpose, that's not in line with the purpose. An additional difficulty is that often in the OECD model, which is, very brief, it's one of the shortest sort of legal documents that I know. It's very brief. There is no official binding explanation for actual treaties. So the only thing you have is the model and some guidance in the commentary. How do you establish what is the purpose of a particular rule? Very difficult. You have to sort of collect that from what you see in the commentary indeed, and there may be writings by authoritative authors. But that's going to be an issue in practice, I think, in the years to come. How do you establish what exactly is the purpose of a particular treaty provision? But it's how, in very general terms, the burden is divided. It all depends on the phrasing of the rule. And I think the rule of Article 29, paragraph 9 in this respect is pretty clear. Application of the rule may be difficult, but the rule itself is clear. I think there is time for one or two more questions, if any.
Well, we have a couple of more questions, but some of them are quite specific. Let me check what would be because some of them, they're clearly for David Borinsky, so they're specifically U.S. international tax focused. Mm-hmm. I do not think it makes much sense to try to answer them now. There is rather interesting. From one of the original questions, non-US related. I skip all US related questions. We leave them to David Borinsky. Mm-hmm. Dear Professor Mlad, could you please comment on the initiative to implement multilateral conventions for MAP to establish international tax dispute standard for any country signed a convention where such convention will cover dispute resolution between non-treaty countries? So basically, the idea is that idea of the question. I'm just trying to understand what was the specific meaning of this. There is a multilateral, so most likely it meant MLI, MAP provision, and international tax dispute resolution standard. For country which signed up for this provision with countries which did not sign for provision of MAP. That would be my understanding of the question. A technical answer would be if the other country didn't sign up for mutual agreement procedure, then there is no, you cannot force them to go to this procedure. And if there is a mutual agreement, then. But in a way, this interacts with your idea of establishing some central authority to to handling disputes. From political perspective, this might be well, difficult to convince all the countries. Like how you convince China to agree to jurisdiction of extraterritorial authority.
Yeah, well, I did see there was another question about the establishment of a sort of a world tax court, whether that should be the task of the United Nations. Well, that's interesting. Of course, you know, United Nations is the sole body in today's world that truly represents the pretty much the entire world. It's the position or the role the UN has played so far in international tax is a little ambivalent. As some of you may know, before the OECD picked up its work, started its work in 1958 on the OECD model, first model of 63, they continued the work that was done till the Second World War by the League of Nations, the predecessor of the United Nations. The UN itself, when it was created in 1948, did not take up international tax. No, that's the reason why OECD stepped in. And in 1980, the UN decided to, in addition to the existing OECD models, to publish their own model. Well, and that model they published in 1980 was for 99% identical to the OECD model. And I must say, in the past 40 years, it has developed tremendously. But it has also shown how difficult it is. I'm a bit familiar with the operation of that UN committee that works on the UN model. It's very difficult to reach compromise there because of the great divergence in interest, even among developing countries, which make up the body of this UN committee. So it's a very interesting suggestion to have this brought under the auspices of the UN. At the same time, what we need is international tax expertise and not politics to get too much involved in international decision-making regarding tax treaties. So, to be honest, I never given much thought to the idea of how the UN could be involved in this particular forum. One of the reasons I like teaching is that you learn yourself. And this is one thing I learned then from this particular person who asked this question, you know, how could we shape a role for the UN in international dispute resolution in matters of international tax? Interesting. Let me think about it. Thank you for the question.
Okay. The question was coming from Niels Rovers, also a Dutch person speaking Russian and Chinese at the same time. That's really remarkable example, international approach of Dutch people like your case. Would you take one last question, which
sure
seems to be interesting? The question comes from Hilde Wampers. Isn't the minimum tax limiting the tax sovereignty of smaller countries that have less means to attract investments compared to larger economies with larger market, cheap labor, transport, etc.?
Well, that's a very interesting question, because that's also at the core often of the investment disputes that go to those arbitral panels, whether an arbitral panel has any say. So basically, whether a bid agreement speaking through the mouth of the arbitral panel has any say on the fiscal sovereignty of the state. Well, from a perspective of public international law, you have sovereignty, you have jurisdictions. States are sovereign and thereby can exercise jurisdiction to make laws, to apply laws, and to decide issues of other laws. One important question is whether tax sovereignty, fiscal sovereignty is of a special nature that nobody can take away the power of a country to make its own tax rules. That's the question. And personally, I answer this question in the confirmative. No, nobody can take away the power to tax from a country. Of course, a country can voluntarily, by concluding a tax treaty, give things away. European Union member states, by joining European Union, they gave away part of their fiscal sovereignty. For example, with respect to rulemaking regarding value-added tax, to take a very simple example. But those are commitments these countries make voluntarily. And the question is, if you, as a country, enter into a bilateral investment treaty, does that give, under the treaty, the power to a private body, like an arbitral panel made up of not of judges, but of practitioners that have been invited by the two parties to serve as a panel member? Do you give those people the right to make inroads on your fiscal sovereignty? Now, my position is no. No. That can only be done, of course, within your own state. Courts have authority over fiscal sovereignty within that state. But vis-a-vis other countries, vis-a-vis foreign courts, foreign bodies, foreign individuals, I think a country can only, through an agreement, give things away. And if it hasn't given away anything, it cannot be assumed by any foreign country, by any foreign body, and so on. So also developing countries, no, they don't lose things. On the other hand, if you enter to a bid and you're afraid of this consequence, you better state expressly in the bid that the bid does not apply to tax matters. And many bids do. And there may be also a problem with many developing countries that were concluding agreements of all sort of nature. Also agreements between a state like Kazakhstan or Indonesia or whatever state, making agreements with Western oil companies for exploration, exploitation, and sort of the deal they made financially by that. These countries often had 30 years ago very little, if any, knowledge on how those things worked. So often these arrangements, these agreements are very unfavorable to these countries. But they were sort of, may say, stupid by not hiring the expertise for them to negotiate these treaties. If a treaty, it's an agreement, it's binding. So also a bid is an agreement, it's binding. If you don't want to have particular things, make sure it's expressly not covered in that agreement. So a lot of the issues with developing countries is that in the past, with past governments, they entered into agreements which, from a legal perspective, weren't all that great, were pretty stupid to the disadvantage of these countries. And the big question is now, how do you get out of those agreements? Well, bilateral investment treaty, you can terminate. That's what countries do. But if you have a private agreement with an oil company, there will be particular clauses, how that thing can be terminated. So that may be costly affairs. So that's sort of a dilemma for developing countries, which may be new to all these issues involving international contracts and so on. You simply got to buy the expertise outside, if you don't have yourself, to make sure that under those agreements, you don't give away things that you really do not want to give away. And you don't want to give away your fiscal sovereignty. And you may give it away by agreeing to open-ended provisions in treaties like bilateral investment treaties. That's sort of an expensive lesson to learn sometimes.
Okay. Kees, thank you very much. So we are way beyond the original time which we scheduled and reserved for this conversation. I would suggest to all participants who didn't get their responses during this conversation to place them on the link page of the event, of which you're all aware, and tomorrow you will receive a reminder as a follow-up email. By this case, I would like to very much thank you for your time, for your expertise, and being prepared to still share your knowledge. I get a question from one of your very former students, like, great having seen Kees after 40 years.
Still going strong.
So thank you. I hope we will see together this international text institution deciding on international cases from central, like, worldwide perspective. It would be great.
Okay, let me thank you, and let me also thank everybody in the audience. It's a pity I cannot see anyone. I know you're there, and I know also that many of you I may know personally quite well. So happy that we could have this contact, and I look forward to the next event that Roestam will be organizing for us. Thank you, Roestam, so much for this initiative. I think it's extremely interesting, and it's very kind of you to spend your time and your energy on organizing this for the benefit of all of us. Thank you so much.
Thanks. Bye.